Good afternoon. My name is Chris DeGroof, Chief Operating Officer for North Star Alliances. I will be your moderator for today's session. Welcome to this webinar sponsored by the City of Los Angeles Department of Cannabis Regulation, Business Licensing and Compliance Assistance Program. BLC programming is designed to assist social equity applicants in Los Angeles in obtaining a commercial cannabis license and operating a successful cannabis business. This installment of our 2025 webinar series focuses on access to capital and investor agreements. Now, before we get started, let's take a moment to review some housekeeping rules. Please note that this webinar is being recorded and can be viewed only on DCR's learning management system after the editing process. You will be muted with cameras off for the duration of the webinar. This means that your camera and audio functions will not be available to you during the session. However, you will be able to see and hear all the panelists. There is an open chat box where you can interact with one another for networking or comment on the information. Please use caution when sharing personal information in a public forum and keep your questions focused on tonight's topic. Please ask questions about the subject matter in the Q&A box. We are gathering and responding to your questions throughout the presentation, and we'll have a Q&A session where you will also get responses in the last portion of this afternoon's event. You are encouraged to utilize the Q&A box at the bottom pane of your Zoom screen. If you use the Q&A box for questions, everyone will be able to see the questions when they are answered. Finally, please note that this content was not created by the Department of Cannabis Regulation or the City of Los Angeles and is for informational purposes only. This information is subject to change and does not replace or supersede the Los Angeles Municipal Code nor constitute legal advice. If you have specific questions outside of tonight's topic, please call area code 213-978-0738 during business hours, which are Monday through Thursday, 10 a.m. to 4 p.m., to speak to a DCR representative. Okay, so now I am pleased to introduce this afternoon's subject matter expert, Zachary Knox. He is the managing partner at the Knox and Ross Law Group and leads the firm's Cannabis Practice Group. Mr. Knox is considered an expert in this field and has spent over a decade advising and representing cannabis companies and entrepreneurs across California. In 2016, he was appointed to serve on the City of Oakland's Cannabis Regulatory Commission and continued to serve in that role through 2019, including serving as the commission's vice chair. Mr. Knox and his firm have been the contract legal service providers for the City of Oakland's Cannabis Equity Program since its inception in 2017. The firm has since been contracted to serve equity programs in the cities of Fresno and San Francisco, as well as outside the state of California. So without further ado, I'd like to ask Zachary to join me on screen. Welcome, Zachary, and feel
Thank,
free to start sharing your screen and start your presentation. Thank you.
thank you for that warm introduction, Chris. And I want to sincerely thank the DCR for having me back again. I really enjoy doing this and sharing what information I have with the applicants. As you heard today, we're going to be talking about access to capital and investor agreements. This will be a two-part presentation. So you guys are here for part one, where we're going to be focusing on accessing capital and talking about some of the things that you need to know and or have in mind as you go out and start seeking to raise funds for your companies. Let's start with a little disclaimer, though. The material that you're going to see in this presentation is for informational purposes only. It should not be considered legal, financial, or other professional advice, and you should consult with an attorney or other appropriate professional to determine what may be best for your individual needs. The information here will have general applicability, and for your specific situation, you will want to discuss that in depth directly with the professional. We do, however, take reasonable steps to ensure that the information published here is accurate, but neither I nor the city of Los Angeles makes any guarantees with this regard. Um, so this is my background. I'm a practicing cannabis attorney, and for those of you who have been consuming the DCR webinar series for years now, probably have seen me do these presentations before. But as I said, today we're going to be talking about access to capital, which will be the part one of this program. So let's get into it. What you see on this slide is the topics that we will be covering today. They include the types of capital that are available, what investors typically want to see, the key terms in investor agreements, how investors try to circumvent equity program protections, your legal rights and how to protect them. We'll identify deal structures that we've seen actually work, and we'll give you some negotiated strategies as you move forward with reaching out to prospective capital partners. So let's get into it. Why does this matter now? Well, every equity entrepreneur needs to understand if you're tier one, that the city of Los Angeles has a requirement that you hold 51% of your business. Capital partners will frame this as a limitation, but I want you to see this as your superpower. While other business owners can be diluted down to next to nothing, you have legal protection that will keep you in control of your business, with the important caveat being, unless you give it up. So what
Hi,
does the
Zachary.
51%?
Can we pause for a second, and can you try resharing your screen, because the Zoom screen size looks really small.
Let's try that again.
Yeah, one more time. Hmm.
Is this helpful?
Oh, that's a little better. There, that's better than it was. Thank you.
No problem. Thank you for jumping in. I believe this is where we left off. So what does the 51% rule really mean for you? You can never be forced below your majority ownership position. You maintain voting control over major business decisions. Investors cannot push you out or take over your company. And you have permanent protection against future dilution below your regulatory limit. So why does this make investors nervous? Why is there so much resistance to this framework? Well, they can't get the control that they're used to having in other contexts. They can't dilute you below the limit in future funding rounds. They can't force you to sell when they decide that they want to make an exit. And so what do they do in response? They get really creative with workarounds that try to strip you of either your economic rights or your voting power, while trying to maintain the semblance of your legal ownership. So that's why this is important right now. Let's talk about the types of capital that are available, because this will somewhat dictate what kind of investors you're running into. The first type is personal and family funding, right? I sometimes joke that these are the three F's, right? Friends, family, and fools. What are the benefits of personal and family funding? You maintain control. Usually your family members and friends are not trying to squeeze you out. The cons, however, is it's often limited funding, meaning it's not enough to kind of get you to the finish line. And if things don't work out, there could potentially be strain on your relationship. This sort of funding is best for initial startup cost if you're just getting started. Maybe application fees, maybe the costs incurred in setting your business up, initial early equipment purchases, that sort of thing. The next category of capital we're going to talk about are angels and angel investors. Now, angel investors are individual investors who are putting in their own money. And in this industry, we can see those investments range anywhere from $25,000 to $500,000. And typically, what those investors will want is anywhere between 10 to 30% of your business, and they'll want involvement in key decisions. Okay. The 10 to 30% is usually dictated on the valuation of your business and sort of your relative bargaining power, right? So this is best for early stage businesses, often with a proven concept. I know that's not always the case here in cannabis, but in an environment like LA, where uh, equity licenses might be the only game in town, for example, with regard to storefront dispensaries, there really is some leverage here that you have with these angel investors. The next type of capital available would be private equity groups. Now, this doesn't have to be the private equity firms that you read about in the newspaper and the Wall Street Journal. Really, what we're referring to here is groups that are pooling money from multiple sources. It might be some of their own money. It might be investors that they reach out to and sort of put together to create a fund that they can turn around and then invest in a cannabis business. These investments are typically anywhere between $500,000 to $5 million, and they will want significant ownership. They will often ask for majority control. And if they can't get majority control, they will absolutely try to seek board control or managerial control of the business. This is best for established businesses that are operating and ready to scale. But in the cannabis industry, this is a very capital intensive industry. And so you may find yourself reaching out to these sort of funding groups even before your business is well established. Uh, Another type of capital available is debt capital. So, what is debt capital? These are loans that must be repaid with interest. Your company is borrowing money, so to speak. Um, you can find debt capital with cannabis friendly lenders. You might be eligible for equipment financing. And we'll talk about the private investors who may want to invest through a debt facility later in this presentation. What are the general pros of using debt capital? Well, you keep your ownership, or at least you're supposed to keep your ownership, right? You are taking a loan, you're going to repay that loan with interest. It shouldn't necessarily be tied to any equity or ownership stake in your company. Um, However, there might be some other hurdles that should be brought to your attention. Loans in this industry often require personal guarantees. They want you individually to sign off as a guarantor of that loan. And we'll talk about whether or not that's appropriate for this industry later. You will also find that because this is the cannabis industry, it tends to have higher interest rates applied to it. Anywhere between the 15 to 30% range is not uncommon in this industry, where in other industries, debt capital is significantly less expensive. And then the final type of capital that we're going to be talking about is revenue-based financing. So what is revenue-based financing? This is you receiving funds in exchange for assigning a percentage of your future revenue to the investor. Typically, what they ask you to assign is anywhere between 2 to 10% of your monthly revenue, and they're looking oftentimes for a 20 to 50% return on their investment. So that's what you see with the 1.2 to 1.5x their investment to be repaid. This is best for businesses that have consistent cash flow, and are really not interested in raising equity capital. And maybe they don't have access to adequate debt capital. So this is another way that they can go. So those are the different types of capital that we most often see used in the cannabis space. So what do these investors really want to see from you? Well, what investors really want to see, particularly in your plan or in your pitch, is your demonstrated understanding of the market that you're entering and the competition that you'll be facing in that market. They'll often want to see anywhere between 3 to 5 years of your financial projections. These will be estimates on how well you think your company will perform. And I think the key thing to note here is that uh, you want your numbers to be realistic. All right. If they think that your numbers are way off or a pipe dream, you're not going to get very far with that investor. So be conservative, be realistic about um, how well you think your business will perform. Be conservative about how much money you're going to say it'll generate. Be conservative and estimate higher costs maybe than what you anticipate. That's typically the case in this industry. One of the most important things that they will want to see is who is involved in your management team. And let me tell you, in this industry and in every industry for that matter, experience matters, especially in cannabis. If you've worked in cannabis before or you have experience running the sort of business that you're trying to start in this industry, you need to highlight and call attention to that. There are plenty of operators who will come, or capital partners who will come and say they'll manage the business for you. But understand they often use that management role as leverage to gain the upper hand in your business relationship. And we'll talk about that later. So the extent that you can demonstrate your own competency in terms of management and your own experience, that's going to be very meaningful for your conversations with investors. Investors will also want to see an exit strategy. One of the questions that they will almost for certain ask is how do they get their money back? And when will they get their money back? So as you put together your plan, be prepared to answer that question. Whether there's an exit built in or you have some other strategy further down the line, make sure that you can speak to that in your conversation with investors. And then finally, what they want to see is your compliance plan. I often joke that you think you're getting into the cannabis industry, but what you're really getting into is the compliance industry. And you may find that some of the capital partners out there and some of these investors don't have a clue about what the compliance requirements are. And so you need to be knowledgeable in those, and you need to be able to speak to that compliance obligation, particularly if you're coming into contact with an investor or a capital partner who is new to cannabis, or more specifically, new to equity cannabis. So, what are some of the red flags that will kill your deal? Unrealistic financial projections, right? Realistic is something that I touched on before, and it is critically important. A lack of cannabis industry experience, a lack of management experience, a poor understanding of the regulations that apply to your business, all of those could be deal breakers. And then finally, if you're asking for money, you have to have a clear idea about what you're going to use that money for. And so that should be reflected in your financial projections and your plans. The last bullet point here is any unwillingness to give up any control whatsoever. When you bring on a capital partner, I want to emphasize the word partner here, particularly if they're an equity investor. And what I mean by equity is not the equity program, but actually ownership in the company. If they are buying into the ownership of your company, then they have voting rights as well. And so any effort to minimize or reduce their participation in that capacity will also be a deal killer. So, what are some of the key terms that you should be aware of in investor agreements? And when we get to part two of this presentation, we will go into depth in investor agreements, but we're going to touch on some of the key terms that you should be aware of already. So, this first one we sort of touched on already when we talked about the different types of capital, and that is equity versus debt. When you are selling equity, you are selling ownership in your business. If you're a corporation, you're selling shares. If you're an LLC, you're selling membership interests. And those securities represent ownership in your business. Debt, on the other hand, is you borrowing money. It's like a loan or a credit card. You're borrowing money, and that money must be repaid, usually with interest. Okay. So, make sure that you are paying attention to if either of those terms appear in a term sheet or later in some other investor agreement. The second term we want to discuss is valuation, because so much of your deal with the capital partner or investor is going to be dependent on the valuation of your business. So, to be more specific, there is what we call a pre-money valuation. Now, this is what your company is worth before you receive the investment. And consequently, a post-money valuation is what your company is worth after that investment comes in. Just to make this clear, I've included an example here. And in this example, your company, let's say, is worth $1 million, and we're going to set that as our pre-money valuation. That doesn't necessarily mean that you have $1 million in cash, but that the company is worth $1 million. This could be the value of your permit or license or the opportunity to obtain one. This could be in the form of eligibility for grants. Maybe you've secured real estate already and that has increased the value of your company. Any of those things. But for the sake of this example, we're going to set your pre-money valuation at $1 million. Now, let's say you need to go and raise another $500,000 in cash, because that's what you're going to use to, say, buy inventory or get equipment or hire employees. And you've decided that $500,000 is your target number, and you found an investor who's willing to invest the $500,000. So the 1 million pre-money valuation plus the $500,000 coming from the investor reaches a $1.5 million post-money valuation. Okay, so real simple math. The 1 million plus the 500,000 equals 1.5 million. And once that investor money comes in, that is now your post-money evaluation. Now, we often get the question, well, how do we determine how much equity we should allocate to an investor? Well, you use this same valuation method to determine that. So in this example, if the investor put up $500,000 and therefore the company reached a post-money valuation of 1.5 million, then the investor's 500,000 is exactly 1/3 of the post-money valuation. So in this scenario, the investor should be looking for a 1/3 interest in the company. Now, that's sort of a rule of thumb, and what you'll find out there in the real world is that bargaining power matters, right? Whether or not you have alternative investment options may impact your relative bargaining power. And if you have good bargaining power, maybe you can capture a premium for the same 500,000. Maybe you're only willing to give 30% instead of 33 1/3. But if you have weak bargaining power and you don't have any other alternatives for capital, the investor may seek a discount. And that happens quite frequently in this industry. Uh, don't be surprised if the investor in this scenario says, I'll put up the 500,000, but I want 49% of the business, right? What they're betting on there is that they have greater bargaining leverage than you do. But you do have program protection as equity applicants in the city of Los Angeles. If you're a tier one applicant, there is a 51% ownership requirement, meaning you must maintain at least 51% stake in your business. This is built-in protection that actually protects you from excess dilution. And by dilution, what I mean is where they try to lower your interest, your ownership interest in the business. But nevertheless, beware, because investors will try to work around this LA program protection. So let's dive into some of the ways investors try to circumvent your 51% protection. And pay close attention here, because these are all real world examples that we've seen in the equity cannabis space here in California. So I'm sorry if these get a little wordy, but we're going to go through them one by one. The first circumvention tactic is what we call the profit allocation scam. Here's the setup. The investor will tell you, you keep 51% of the ownership because that's required, and give me 49. But we're going to do something different on the split of profits. We're going to give you 20%, and we're going to take 80% of the profits because we're putting up all the money. What's their common justification? Well, you have your ownership, but we need a greater return for the risk that we're taking, being the only capital partner. What happens in reality is that you end up doing all the work and they get almost all the money. So be on the lookout for the red flag language for a profit allocation scam. They may characterize this as preferred returns, carried interest, and promote structure. Now, I want to be clear, just because this language may show up in agreement does not necessarily mean that those clauses are predatory, but I want to highlight them for you, because when you see this language, you need to scrutinize the agreement even more carefully. The second circumvention tactic that we're going to talk about is what we call the special voting rights trap. Again, here's the setup. You own 51% like you're required to, but the investor's ownership carries a higher voting power than your ownership, right? So, for example, they may have 3 times the voting power. And the consequence is that your 51% ownership does not result in 51% of the voting power. They'll often justify this by, again, saying that we need to protect our investment. We have responsibilities to our investors and our shareholders. And so we need this higher voting power. The reality here is that if you fall into this trap, then you can't make major decisions in your own company, right? So again, red flag language, any different classes of shares, for example here, Class A or Class B shares, super voting rights or weighted voting. Now again, just because this language appears does not mean it's predatory. And there's a way that some of these clauses could be drafted to your benefit. But again, if you see this sort of language coming up in a term sheet or an investment agreement, it's going to be really important that you scrutinize that language very carefully. The next investor circumvention tactic that we're going to talk about is the buyout trigger time bomb. And here's the setup. It's typically an automatic sale clause that's hidden in your agreement. And some of the common triggers for that sales clause is if the company is missing revenue targets, or maybe there's regulatory changes. One of the common ones that we see is uh, if the local municipality changes its regulations or ordinance to allow an equity partner to dilute, then somehow that becomes an automatic trigger of a buyout clause. So regulatory changes, that's another one to look out for. If investors want to exit, right? Maybe they're 3 years in and they want to get out, and they may try to force you to sell along with them so that they can make that exit. That's actually what the reality is. You may end up being forced to sell your business or your equity at below market prices, just so those investors can get out when they want to get out or have some other justification to do so. They will often characterize it as standard protection language. And so the red flag language that you want to look out for are put options, drag along rights, or any mandatory sales events. The next circumvention tactic we want to talk about is a very common one, and this is the management fee drain. The setup is the investor is going to put capital in your business, but they want you to contract with them to provide management services or contract their affiliated business that provides management services. And then they're going to want to charge you reasonable management fees for that service. These fees can typically range anywhere from 5 to 15% of the revenue. Um, and that revenue would go directly to the investor or investor controlled entities. What is the impact of this? Your business could be very well be profitable, but ultimately generate little in cash because of the fees. Those fees could be used to extract value out of your business on the top line, the revenue line, before your costs, before your profit, and before you yourself can be paid. Oftentimes, these fees can even be expanded beyond management. They'll show up as consulting fees or brand licensing fees, or maybe your capital partner wants to lease the equipment from them. So again, the red flag language that we're looking out for here is management service agreements, strategic consulting, or other administrative fees or costs. And I will say that there's room in this industry for all those services, but I think you have to look at them very carefully when your investor either controls or is somehow affiliated with those companies that are going to be providing services. And if they are, then you really need to scrutinize that relationship to make sure that it has the appearance of an arm's length transaction and that the fees that are being charged are fair for the services that you receive. Uh, One of the more important circumvention tactics that we want to talk about is what we call the debt and equity double dip. This is where the investor wants to invest in your company as an equity investment, but also loan money to the company. Another way we see this set up is where the investor demands equity in exchange for solely debt financing. The trap here can be they might ask you to make a personal guarantee on the debt portion, or if they're doing both debt and equity financing, that the amount of money they put up for equity is not in alignment with the amount of equity they want allocated. Okay. The result here is that If your business struggles, you could be personally liable for the debt while the investor gets to keep their equity in your business. They will often frame this as just being risk protection, or they need to spread the risk out between debt and equity. So be on the lookout for any language referencing hybrid financing, mezzanine funding, or convertible debt with guarantees. Oftentimes, those are indicative that there may be a double dip coming. So, what are your legal rights here, and how do you go about protecting them? Well, make sure you understand what your non-negotiables are. And we're going to discuss that on this slide. This is what you should never accept. Economic rights that don't match your ownership percentage. If you own 51%, you get 51% of the profits, period. If you find yourself in a position where you have no choice but to negotiate a preferential distribution for the investor, then make sure that at some point that preference sunsets and the distribution reverts back to being based on your percentage ownership in the company. But ideally, we would want no preferred distributions, no preferred waterfall structures that favor the investors, and no management fees that exceed their actual documented costs. If they're a partner in your business, they need to be a partner, not try to profit off your business. The other non-negotiable should be voting control that does not match your ownership interest. What I mean by that is one share should equal one vote, no exceptions. No super voting shares, no weighted voting shares. You want to make sure that you are in the position to make operational decisions, and the investor's input should be advisory only. They should be participating at the ownership level, not the day-to-day operations level, unless they have the expertise to do so and you separately contract for that. But they should not be granted that level of control just on the strength that they've invested in your business. Automatic buyout triggers. Do not accept any clause that forces you to sell based on performance metrics. Do not accept any put options that lets investors force you to buy them out, and no drag-along rights that forces you to sell just because the investor is ready to make an exit. Now, you could flip those provisions so that they are in your favor, but do not accept them in favor of the investor. You should also never accept personal guarantees on investor funds. They are investing in a business, and their investment should be at risk, not guaranteed. So don't ever accept personal liability for their return on investment. Your personal assets should never be treated as collateral for business investments. So let's take a look at some of the deal structures that actually work pretty well. The first one is my preferred, just a simple equity partnership. A clean 51-49% split of ownership that applies to profits and voting. And if you're giving up to 49%, make sure that the amount of money that the investor is contributing is in alignment with the value of the equity vis-a-vis the value of the company. In this setup, both parties share in success and risk of the business proportionally, and there should be clear exit terms that respect both parties' interests. Another structure that I've seen work is revenue sharing with an equity upside. Maybe the investor gets a fixed percentage of revenue, 3 to 8%, plus a small equity stake, 10 to 20% for long-term upside. In this scenario, you maintain majority control and have the majority of the economic participation. And then finally, if an investor is really interested in debt and equity, right, then let's talk about convertible notes with caps. These are short-term debt instruments that they can convert to equity later if they decide they want equity in the company. However, if you go down this path, you're going to want to make sure that that conversion is capped to ensure that you never go below the 51%. So let's say I issue a convertible note for $100,000 and the company pays back half of it, right? So now I'm still owed $50,000. I may decide under my convertible note that I want to convert that 50,000 to equity rather than collect the remaining 50,000 of the debt. At that time, that 50,000 would be measured against the value of the company, and that will dictate how much equity I'm allocated on conversion. And again, just make sure that there's a cap in place to ensure that you're not diluted below 51% on that conversion. The benefit here is that the investor gets a return through growth of the business rather than control of the business. So what are some of the negotiation strategies that you can employ when you're having these conversations with capital partners and investors? Well, first, understand what's negotiable and what's not. What's usually negotiable are the valuation of the company, the composition of the company's board or management committee, the level of involvement the investor will have, any sort of liquidation preferences if the company is sold or closed for business, and then any anti-dilution terms. But it's also important for you to know what's not negotiable. Compliance with cannabis law, including equity program requirements, are not negotiable. Basic investor protections are not negotiable, and financial reporting requirements are not negotiable. So my recommendation to you, and you may have heard me say this in other presentations, is know what you want and what you're worth. Protect your interests. Maintain enough ownership so that you stay motivated on these projects, and these projects are challenging and they will test you. You need to stay motivated, and nothing will diminish your motivation more than having a reduced amount of ownership. Keep operational control of your day-to-day business and negotiate fair board representation. Include performance milestones for additional funding. And know your worth. Research comparable businesses. What are other cannabis businesses worth? What are other equity cannabis businesses worth? Understand what your revenue potential is and factor in any unique advantages you may have. Maybe you have a location. Maybe you have licenses in place already. Maybe you have members on your team with a tremendous amount of experience in this industry. Leverage all of that. Okay, I think that is the conclusion of part one of this presentation. I think we're ready to go to Q&A. So
Yes.
I just want to say thank everyone for attending and make sure that you check up on the upcoming DCR webinar series schedule for part two, where we're going to dive into investor agreements. I'm going to stop my share now, Chris, and maybe we can get into Q&A.
Yeah. All right. Thank you so much, Zachary. I've seen a few of your webinars before, and you always present so much wonderful information. So again, thank you for that. We do have a few questions. The first comes in from Alexis, and she asks, my partners and investor are on the brink of insolvency. Can you provide a brief discussion on how to navigate a situation where receivership may be imminent? In particular, how a social equity applicant can retain ownership and control of their interest in the company when investors slash equity partners are forked out due to lack of operational liquidity.
So let me start by asking for a clarification on that, Chris, and maybe I missed it when you read the question. Is it the cannabis business that's insolvent and at risk of receivership, or is it the investor entity that's insolvent and at risk of receivership?
That's a good question. I'll repeat the question, and maybe if Alexis is still on and listening, she can add that. Okay, she just responded. The investor entity. So I'll reread the question. So this is regarding the investor entity. My
Mhm.
partners and investor are on the brink of insolvency. Can you provide a brief discussion on how to navigate a situation where receivership may be imminent? In particular, how a social equity applicant can retain ownership and control of their interest in the company when investors slash equity partners are forced out due to lack of operational liquidity.
So that's a great question, and it's not an uncommon scenario. What I would tell you, Alexis, is that your partners going into receivership should not have a tremendous impact on your operations. Typically, when a business goes into receivership, whether it's because of a partnership dispute or some other hurdle that that business is facing, that receiver is coming in to manage the assets, in your case, of your partnership entity. And it's their job to preserve those assets to the best of their ability until whatever issue that's going on with your partners can be resolved. And if it's a liquidity issue, it may very well be debt collectors coming after them. It may be a dispute between the partners. Maybe there's some disagreement about how the money's being managed that may run into liquidity issues. Um, when and if that receiver is appointed, they're going to be stepping into the shoes of your partner, and they are still subject to all the agreements that are in place with your partners. So if they have a certain amount of voting control, the receiver is going to be able to exercise that voting control. If they are entitled to a certain level of economic participation, it's going to be the receiver's job to protect and preserve uh, those resources as they come in. Um, so, what is the practical impact to you when you're operating your business? It's as though your partners will have a substitute standing in for them. But unless there's something very unique in how your business is organized or how your relationship with your partners is documented, there shouldn't be a tremendous amount of impact on your own operation.
Great. Thank you, Zachary, for that. Now we have a couple more questions somewhat related to each other, not the one you just answered. So we have one from Ken, and he's asking, where should a new cannabis tech company, POS software, turn to seek funding?
Yeah, so that's a great question. And if you're talking about a tech company, you're really talking about a business that's tangential to licensed activity, right? Um, and so, what I would suggest to you that if you're in the tech space, then you would go to those same, likely go to those same investment circles that any other tech business would go to when they're trying to raise capital. It's just that you're going to have a narrow focus on a tech product that is related to the cannabis industry. I often recommend uh, folks who are interested in being involved in cannabis but are unsure about whether or not they want to get involved in licensed activity themselves to look at some of these tangential business lines, whether it's software to support cannabis businesses, whether it's services to support cannabis businesses, where you don't necessarily have to get yourself involved uh, in the licensed activity. Um, but without knowing more about your product, it's kind of hard for me to discuss how it might differentiate from what else is out there and how that might impact what investment circles you could target. But as a general matter, I would say the same investors who understand tech products, whether it's POS systems or online dashboards for, let's say, delivery sales, um, that same knowledge set would apply to whether the product is targeting cannabis businesses or targeting non-cannabis businesses. So I think you would find investors in that circle might be the right people to approach about that opportunity.
Great, thank you. Similarly, Freddie asks, and this is, I suspect, a similar answer. Where do I look for investors?
Oh, that's the $1 million question, right? Um, I would say they're all over the place, but they're not necessarily going to pop up right in front of you. So this is where it becomes really important to network, to go to industry events, and you may not meet the investor directly there, but you might meet somebody who knows somebody, right? And that's one of the common ways these things get put together. Yeah, there might be some large groups out there. I'm sure many of the people on this webinar are familiar with some of the multi-state operators, or the MSOs as we call them, um, that are investing in this industry. That may or may not be the right fit for you. So I tell people, beat the street, so to speak. Make sure you're going and showing up at cannabis industry events. Make sure you're talking to people who have successfully raised money before. Some of your colleagues here who are already operating may have networks out there. And so there's no one place to go to find these sorts of investors. You kind of got to beat the street and make sure that you're doing the networking lift.
Great, thank you. We're going to jump back to Ken. He's the one with the tech POS. He expands and says it's called Weed Hurry, and he asks, how important is a brand of your business as a leverage for investment?
Um, I would say that if you're an established brand with brand recognition out there in the marketplace, it's really important and it's really valuable. Um, Probably less so if you're a new brand or an unrecognized brand that's still trying to establish yourself. Investors in that scenario will know that part of what they're investing in, or part of the use of funds for their investment, might be brand development and building your brand and building awareness and recognition around your brand. Um, so, at an early stage, it's probably not as important. Although, if you've done some clever branding and you have, some collateral that's attractive, that might be sort of the frosting on the cake. But I think the fundamentals of your business are going to be much more important to investors if you're a new company.
Okay, great. Uh, D-Boss CEO asks, can you provide a list of potential angel investors slash venture capital firms friendly to the cannabis operators? So I'm not sure about that, but go
Yeah,
ahead.
I don't know that I have that list.
Yeah.
I would say one of the challenges in the California market right now is that we're a fairly mature market as far as cannabis goes. And what that has meant for folks in your position is that it is getting harder and harder to raise capital, often because a lot of the easy money, as we would call it, are going to new emerging cannabis markets where maybe the regulation is not as robust, maybe the oversight is not quite there, and the enforcement is not quite there. And they think that their money can stretch further in those environments. That doesn't mean that there isn't any money left to be invested in cannabis in California, but you might have to work harder to get it now, work harder to find it. Investors are going to scrutinize your business more closely and carefully than they had in the past. And so I'm not going to mince words with you. It's going to be a challenge, right? I tell operators the two biggest challenges in this industry right now is the investment piece and the real estate piece. And so I don't want to disillusion you about it. It's going to take some work, but I don't know that there are any Rolodexes out there or databases of angels or venture funds that specifically cater to cannabis.
Okay, great. Thank you. DTR has given us permission to go a few more minutes, Zachary, and I think there's a couple more questions that are important to answer. You spoke a lot about the 51% rule, and can you clarify what happens if an equity entrepreneur unknowingly signs documents that circumvent the 51% rule? Is there any legal recourse after the fact?
So this is a great question. And a lot of people find themselves in this position. And there is a regulatory side of this, and then there is a civil dispute side of this. And so if you find yourself in that situation, I think the first thing that you need to rely on is the protection of the DCR. It is their rule, it is their requirement. And if they are enforcing the rules, then in my opinion, there should be a real question about whether or not the business can continue operating if it's no longer in compliance, whether or not their permit is still good if the business is not in compliance. And so that would be your first leverage with the investor. Hey, we need to change this and bring this agreement into compliance, or we might find that we can't operate at all. And you don't necessarily want to lose your investment, investor, do you? Because we can no longer operate. And so that's sort of the regulatory leverage that you may have. And that you may find that that is the best avenue, um, because on the civil side, contract law sort of says this is the agreement you entered into. And if you had an opportunity to have the agreement reviewed by professional representation and you were made aware of these issues and you signed it anyway, um, then you might be stuck with it, right? Um, or you may end up finding that you have to reach some sort of settlement to get the other side to agree, right? Now, I would say these situations are largely fact dependent. Um, Predators slip up all the time, right? So if they coerced you or they pressured you and didn't give you the opportunity to seek your own professional guidance, or if they insisted, for example, that you use their attorney who's compromised um, and has a conflict of interest, there may be loopholes that you can use to legally get out of the agreement. But I think that those are, much more risky in terms of what the ultimate outcome will be. And oftentimes, if you have to go to litigate or initiate a legal dispute to resolve this, that's going to cost you money. And some of these predatory investors are relying on the fact that you don't have the resources to put up the fight to sort of quell your complaining about the terms of the deal. So I would always recommend start off with going to your regulator and seeing if they can assist you to put any pressure on your partners to amend the deal so that it comes into compliance with the requirements.
Great. All right, last question, unless someone adds one here. So everyone's always worried about the costs. So how much should an equity entrepreneur budget for legal fees during the investment process? And what's the difference in cost between reviewing investor documents versus having your own attorney draft them?
Um, well, fortunately for everybody who is a program participant with the DCR, I believe the LA County Association is providing a limited amount of pro bono and what we would call low bono service hours. And I would highly encourage you to take advantage of those if you haven't already, particularly when it comes to document review. In terms of costs, of course, it's going to be a lot less expensive for an attorney to review documents as opposed to having to draft them from scratch. But let's talk about what that scenario might actually look like. Um, what that contemplates is that maybe the investor or the investor's attorney has prepared those documents. Now, if the documents are sound, and you just need them to be reviewed to verify that they're sound, then that might be a less expensive way to go. But if those documents are flawed, then even having your own counsel simply review them may only bring those flaws to your attention. And then you still have to go through a fair amount of negotiation and redrafting to get the documents to a state to where they need to be. Um, Hiring your own attorney to draft the documents for you from scratch may ensure that those documents are compliant from the get-go. But once again, um, now that you have your own attorney preparing documents, the investor's attorney is going to want to review them and potentially negotiate with them on the terms. So there may not be any sort of getting around that. As far as estimated dollar figures, that's going to be highly dependent on the circumstances. What is the size of an investment? What sort of business are they investing into? What mechanism, or excuse me, what type of capital they're going to be putting in? But you can see anywhere from, you know, a few $1,000s to tens of thousands of dollars, depending on the nature of the deal.
Right. I'm sure all your answers have been so helpful to all of our attendees.
Oh, thank you.
So we'll move forward with closing. I'd like to thank you, Zachary, for presenting and giving us all this great information. I would also like to thank all of our attendees who attended this informative webinar offered by the City of Los Angeles Department of Cannabis Regulation. The webinar recording will be found on DCR's Learning Management System. If you have any questions on accessing your account, please email dcr.sep@lacity.org. And thanks again for joining us. Have a wonderful rest of your day.